All rise.
Hearing in the appeal, Austin against Mayor and Burgesses of the London Borough of Southwark.
Mr. Luke, could I mention before you begin a matter of timing?
Yes.
We asked that the court should sit at 10 o'clock tomorrow morning. What we propose to do is to sit on until lunchtime tomorrow. It may be that there's a reasonable chance of actually finishing by lunchtime, and that would be convenient for various reasons if that could be achieved. But I hope it doesn't inconvenience counsel too much if we sit at 10.
And I'm grateful to my Lord, and we are all at the bar for the indication having come in advance, so we've made the necessary arrangements.
Thank you very much indeed.
Thank you. My Lords, my Lady, in this matter I appear with Mr Desmond Rutledge for the appellant Mr Barry Austin, the respondent Southwark London Borough Council, represented by my learned friends Mr Drabble, Queen's Counsel, and Mr Shaw Kelly. My Lords and my Lady will have seen that we have identified 5 issues on which we would invite the attention of this court, and I'd propose to deal with them in the sequence set out in the agreed statement of facts and issues, starting with issue 1, which might broadly be described as the tolerated trespasser question. The question posed for this court by issue 1 is whether the possession order made against him ended the late Mr Alan Austin's tenancy, or whether, in the alternative, he was, at the date of his death, still the tenant of the council. That's the issue to which the first of the matters on this appeal goes. May I start on that issue very briefly with the possession order itself, which is the operative instrument. That is to be found in the appendix at page 5. May I, before coming to its terms, simply put it in its procedural context. The court will recall that 52 Michael Faraday House, described in the first paragraph of the order on page 5, is a one-bedroom council flat which was let to Mr Alan Austin in July of 1983. The possession claim, which led to the making of the possession order on page 5, was brought under the claim form at page 3 in June 1986. So he'd been a tenant for a little under 3 years by the time the claim was brought. As page 4 indicates, the initial possession proceedings were adjourned over to the hearing on the 4th of February 1987, when the order for possession was made. In a departure from other methods of recording court proceedings, there's no indication on the form of order as to whether the defendant attended the hearing. The form used, I'm afraid that the court can only just see this from the bottom left-hand side, is the standard template form N28, a suspended order for recovery of land, which was the form required under Order 22 of the old County Court rules, where an order for recovery of possession was to be suspended.
Is it the form currently in use?
No, my Lord, it's not. No. The form currently in use is substantially different, not least in that the form currently in use provides for a date on which possession is to be delivered up.
Lord Newberger, I think, referred to that, didn't he, as a form that had been designed differently.
Indeed, my Lord. What happened was that the form was twice revised after the making of this order in 1987. It was first revised in 1993, when provision was made for the addition of a date, and it was further revised in 2001. Part of the reason for all the recent attention to the tolerated trespasser question was that in 2006, the Court of Appeal decided that the form in use since 2001 had in fact been an order for outright possession rather than suspended. And that meant that vast numbers of people who had not been thought to be tolerated trespassers had been since 2001.
That was the Harlow case.
That was, my lord, yes.
This looks like a forthwith possession.
Indeed it does, my lady. And as we shall see in just a few moments, Lord Justice Millett, as he then was, thought that the Court of Appeal might have interpreted in Thompson and Elmbridge this form of order as it were being an outright order for possession.
I wasn't suggesting it was an outright order, I was suggesting it was an order for possession forthwith, suspended for 28 days on conditions.
Yes, my lady, that's been part of the difficulty in framing the template orders under Section 85 of the Housing Act 1985. It appears that draftsmen have not really got their heads round the distinction between the delivery of possession, that is the order for possession, and then the execution of that order. And as my lady says, if I may say so perfectly properly, this appears to be an order for possession under which execution of the order is made conditional. However, that is not how it's been interpreted. One might think, surprisingly, and when it was so interpreted in Harlow and Hall, then that was the dynamic for the changes that then took place. So, well, my lady is ahead of certainly me in terms of the terminology of the order. I took my lords and my lady to the description of the order as Form N28, Suspended Order for Recovery of Land, but the terms of the order are in the first paragraph that it is adjudged that the plaintiff do recover against the defendant possession of the land mentioned, and in the second paragraph a monetary judgment for arrears of rent and cost of £95, coming to, as the court will appreciate, the wrong total figure. The figure is in fact £100 higher. In the third paragraph, it's ordered that the judgment for possession shall not be enforced for 28 days in any event, and for so long thereafter as the defendant punctually pays the plaintiff or his agent the arrears of rent, mean profits and costs by the 4th of March 1987. We shall see shortly that the words which have been blanked out there, and indeed you can just make out the last of them, are per week in addition to the current rent, because the common use of this form would be to require instalments of X pounds per week in addition to the current rent. Those words have been deleted in this case to provide that everything must be paid by the 4th of March 1987.
Do you suppose that anybody intended that?
To delete it, my lady.
Do you suppose that anybody intended that the whole arrears should be paid by the 4th of March 87? Seems extremely unlikely.
Indeed, my lady. It is a sad fact that these cases are dealt with in great bulk. The judges do not complete the orders. They simply usually fill in a pro forma provided by the court staff. And the court staff then take away the pro forma and transfer it onto this template. If it's any comfort, the prospects for this template being correctly completed are better, as reflected by the fact that it's being completed in handwriting, than has been possible with the benefit of information technology.
It rather suggests that Mr. Austin probably wasn't present, because no proposals were made about the payment of arrears.
I accept that inference, my lord, but I can't confirm
No,
it
of course not.
one way or the other.
It's speculation, really.
It's simply speculation, my lord, but it is indeed extraordinary that it might be contemplated that the council tenant who is behind with his rent is going to find £3,400 odd in the next 28 days and pay it, and thereby achieve what appears, as my lady's already indicated to be, the stay of enforcement of the order for possession which has already been made.
Well, I find it astonishing. I mean,
And what's to be meant by the first payment, then, if it's all to be paid in a single figure? I don't understand that. I mean, rather, there's an indication that there might be instalments, but you don't know what they are.
well, it does actually, of course, go on to say the whole thing's got to be paid on the 4th of March, but it just seems extraordinary.
Well, nothing may be added by going over the forensics of it in any greater detail, save to point out, for example, that it doesn't provide that he's got to pay the current rent until the 4th of March, because by accident those words have been deleted as well.
Yeah.
It provides he's got to pay to the plaintiff the arrears of rent, mean profits and costs, which, as my lady suggests, rather suggests that the intention is to be an immediate order for possession, or at least unqualified order for possession. However, this was the template designed for suspended orders. It can only be inferred that that's what the district judge or judge thought he was doing in making the order in these terms. And we note further on in the order that, of course, the entry for current rent to be stipulated has been omitted.
Well, there we are. That's
Well, that's
warts and all. That's the form.
Well, warts and all, my lord, and not unrepresentative of exactly the sorts of orders that I'm afraid were, and still are to a certain extent, being made in the hurly-burly of the county court. Indeed, we see from the note, which is on the prescribed form under the words "take notice," that the rubric is that if you're ill or out of work, you should ask your landlord to suspend the order until you're better back at work. If he will not do so, you should ask the court officials to help you prepare an application to the judge, presumably inferentially to suspend the order, which apparently has already been suspended, or this is the template for a suspended order. However, warts and all, that is the order for possession that was made. Tens of thousands of orders in this form, N28, are and were in 1987 made each year, and as I've indicated, sadly, often with just about the same care to detail. As the court knows, the defendant, Mr. Alan Austin, did not leave the property on the 4th of March or at any date thereafter, nor did he comply with the obligation to pay the £3,400 odd by the 4th of March 1987, so that the order certainly became enforceable on the 4th of March 1987. It never was enforced, and as we know, Mr. Alan Austin was still there in that flat on his death some 18 years later in February 2005. The tenancy which Mr. Alan Austin had been a secure tenancy, and secure tenancies had been first introduced by the Housing Act of 1980. By 1987, when this order was made, the provisions had been consolidated into the Housing Act of 1985. And we have in the bound volumes, in volume 4 at tab 42, the Act as it stood on consolidation, and therefore as it was operative on the date of making of the possession order. Volume 4, tab 42. I apologise to the court, it would have been more usual perhaps to have the statutory provision in the appendix, but that in the appendix is the current version of the amended Act.
Yes.
Behind tab 42 we have the provisions of the Housing Act 1985 Queen's Printer's copy, and we have reproduced at the page 41, using the numbering at the top of the pages, the sections material to the grant of possession against a secure tenant. Section 82 is the section which bears the marginal note security of tenure, and it provides that a secure tenancy which is either a weekly or other periodic tenancy, we needn't read the B, cannot be brought to an end by the landlord except by obtaining an order of the court for possession of the dwelling house. Section 82(1) envisages, therefore, termination by the landlord obtaining an order of the court for possession, and what we've been looking at is an order of the court for possession. Section 82(2) provides that where the landlord obtains an order for possession of the dwelling house, the tenancy ends on the date on which the tenant is to give up possession in pursuance of the order. And it is Section 82(2) and the interpretation thereof that has caused some of the difficulties in relation to tolerated trespass, and to which I shall have to return in just a few moments. However, the importance of Section 82 for present purposes is that it provides that the secure tenant has security of tenure because the tenancy can only be brought to an end by the landlord by obtaining an order for possession. The remaining provisions of what is Part 4 of the 1985 Act will be very familiar, I think, to members of the court. The Section 83 provides for a preliminary notice of proceedings for possession, so that the tenant is in effect given a warning. Section 84 provides a statutory injunction in Section 84(1) that the court shall not make an order for possession of a dwelling house let under a secure tenancy except on one or more of the grounds set out in Schedule 2, so that the making of a possession order is conditional upon the landlord having satisfied one of the statutory grounds. Furthermore, section 84(2) provides conditions in addition to grounds. It provides that the court shall not make an order for possession on the grounds set out in Part 1 of Schedule 2 unless it considers it reasonable, on the grounds set out in Part 2 of that schedule unless satisfied suitable alternative accommodation will be available, or C, on the grounds set out in Part 3 unless it both considers it reasonable to make the order and is satisfied suitable alternative accommodation will be available. So it is always necessary for the landlord of a secure tenant to establish for the court both a ground for possession and that the relevant condition in section 84(2) is made out. And of course, the link between the warning notice and the ground for possession is made by section 84(3), which provided that the court shall not make an order on any of those grounds unless the ground is specified in the notice, in pursuance of which proceedings for possession are begun. Section 85 then contains, importantly, what is described as the extended discretion of the court in certain proceedings for possession. And it provides a series of extended discretions available to the court. Section 85(1) provides that where proceedings are brought for possession of a dwelling house let under a secure tenancy on any of the grounds set out in Part 1 or Part 3, that is to say, cases in which the court must be satisfied that it's reasonable to make a possession order, the court may adjourn the proceedings for such period or periods as it thinks fit. It is important, therefore, to appreciate that the statutory extra discretions contained in section 85 are limited to those cases in which the condition is that it must be reasonable to order possession. Subsection 2, having dealt with adjournment in subsection 85(1), subsection 85(2) provides that on the making of an order for possession of such a dwelling house on any of those grounds, or at any time before execution of the order, the court may A, suspend or stay or suspend the execution of the order, or B, postpone the date of possession for such period or periods as the court thinks fit. So included in that extended discretion are two discretions, in A, referring to execution of the order, and in B, referring to postponement of the date for possession. It has been observed judicially on more than one occasion that the subsection may have been more sensibly structured to have reversed A and B, to deal first with postponement of the date for possession and then to deal with stay or suspension of execution. Subsection 3 makes provision for conditions and provides that on an adjournment, stay, suspension or postponement, the court shall impose conditions in respect of payment by the tenant of arrears of rent, if any, and rent or payments in respect of occupation after the termination of the tenancy, mean profits, unless it considers that to do so would cause exceptional hardship to the tenant or would otherwise be unreasonable, and it may impose such other conditions as it thinks fit. 4. If the conditions are complied with, the court may, if it thinks fit, discharge or rescind the order for possession. Subsection 5 then makes provisions in relation to spouses and former spouses and provides that where proceedings are brought for possession of a dwelling house let under a secure tenancy and a tenant's spouse or former spouse having rights of occupation under the Matrimony Homes Act is then in occupation, and B, the tenancy is terminated as a result of those proceedings, the spouse or former spouse shall, so long as he or she remains in occupation, have the same rights in relation to or in connection with any adjournment, stay, suspension or postponement in pursuance of this section as he or she would have if those rights of occupation were not affected by the termination of the tenancy.
Subsection 5 has been taken out. Subsection 5 is no longer there, am I right?
Indeed, my lord, two things happened. First of all, subsection 5 was extended to deal with cohabitees and others by the addition of a subsection 5A.
Yes.
And then, most recently, both 5 and 5A have been repealed.
And are they reenacted in some other form, or are they just simply gone?
No, my lord, they've simply gone, and the reason that they've simply gone is, as my lord well appreciates, that section 82 itself has been amended to remove section 82(2) and to provide that the tenancy only ends on execution of the order.
Yes, I see.
So there never needs to be an application in relation by a spouse in relation to a terminated tenancy, because the tenancy can't terminate.
And so far as we're looking at the original subsection 5, it doesn't actually, it's not conditional on the other partner of the spouse being still alive.
Exactly so, my lord. And as my lord appreciates,
Which is a
that's
point you're going to come
we
back
take, yes.
to.
Yes. Well, we deploy it in two senses, my lord. First, it shows a statutory intention that the extended discretion may be available to others than the person who was the original secure tenant, i.e. their spouse or former spouse, but also that it postulates the situation that the spouse or former spouse, the other spouse or former spouse, may apply even though the original tenant is dead. My lords and my lady, those are the provisions which deal with the making of orders of possession so far as they were concerned and contained in the primary statute.
Mr. Luber, can you just help me with one point? It hasn't previously occurred to me that subsection 4 provides a discretion. Now, one might have thought that where you'd made a conditional possession order and the condition was fulfilled, you ought to have a duty to rescind the order.
Well, my lady, if I may say so, in policy terms, it may have been contemplated that whilst you were complying with the conditions, something else may have arisen.
Yes.
For example, one of the cases included in the bundle is a case of Finn, in which the lady had a possession order made against her conditionally on terms as to payment of arrears of rent, but then misbehaved in the property. And the question was, well, could the landlord then go back to court, as it were, and unscramble the original terms based on these new situations? So that I suppose, my lady, it may have been contemplated that you'd have a situation under 85.4 where a person would come forward and say, well, I've paid off in accordance with the arrangement, and the landlords would say, well, hold on a minute, don't rescind the order because there's this other matter.
So the landlord didn't have to start from scratch again in those situations?
That was what that is what the Court of Appeal decided in the Manchester and Finn case. Because if it had to start again, then you might have a situation in which there were two possession orders operative in relation to the same property, which is not entirely attractive.
Well, no, I was suggesting that it ought to
be treated as automatic, as it were.
or have a duty to rescind it, and therefore, if the condition had been complied, treat it. But never mind. That's a side wind. I'm just noticing things that I hadn't noticed before.
I'm obliged, my lady. Of course, one of the issues which we don't have to address, thankfully, in this appeal, is the extent to which a court could express itself in the original order as to what would happen if you did comply with all the conditions. So it might say in the original order, this order shall be treated as discharged if you clear all the arrears. And when the template form was redesigned in 1993, there was further consideration of the last paragraph of what we have in our order, the very last paragraph above the heading current rent. I'm back on page 5 of the appendix, and where the order provides through the words "and also" that the judgments indeed shall cease to be enforceable when the arrears of rent, mean profits and costs referred to above are satisfied.
That could be expanded or qualified, you suggest?
Well, my lord, it could, as I was suggesting in answer to the question from Lady Hale, perhaps deal more explicitly with the discharge or rescission of the order itself.
Yes.
So that a judge could provide not simply that the order will cease to be enforceable when the rent arrears, etc., are paid, but that the order shall thereupon stand discharged. But I think, as my lady correctly observed, I don't think I can help further on that point usefully in relation to the present appeal. My lords and my lady, the question of the impact of a possession order in a form such as that made in respect to Mr. Alan Austin was first considered on appeal in the case of Thompson and Elmbridge, which the court has at volume 3, tab 33. And it's one of only 3 authorities on this point to which we will need to go. Thompson and Elmbridge, volume 3, tab 33. Well, Lord, can I very briefly take the rather unusual facts of Thompson and Elmbridge from the head note, which is on page 1425. The local authority granted a tenancy of the dwelling to the applicant's wife. That tenancy was a secure tenancy. The wife fell into arrears of rent, and in January 85, the local authority obtained an order in the county court for possession of the property that was not to be enforced, quote, for 28 days in any event, and so on. And we shall look at that order in just a moment. The wife, as a result of matrimonial problems, departed permanently from the house in August 1985, and by September had permitted arrears of rent to accumulate so as to be in breach of the court order. Thereafter, the applicant, that is to say her husband, who was unemployed, remained in occupation of the property, current rent being paid by the DHSS. In January 1986, when the applicant was still in occupation, the local authority obtained a warrant for possession of the property against the wife from the county court office. Thereupon, the applicant, by way of originating application, applied to the county court to be added as a defendant in the possession proceedings taken by the local authority against his wife, so as to be able, in the course of divorce proceedings, to have the tenancy of the property transferred to him by virtue of provisions of the Matrimonial Homes Act. On the 28th of January, the judge refused the application on the ground that, pursuant to section 82(1), the secure tenancy had terminated before the date of the application. The judge also dismissed an alternative claim by the applicant under the provisions of section 3 of the Protection of Conviction Act. On appeal, held 1, dismissing the appeal, 1, that since by virtue of section 82(1), a secure tenancy terminated on the date when a tenant had to give up possession under a possession order, where a secure tenant failed to comply with the terms of the possession order, suspended pending punctual payment of current rent in arrears, and was thereby in breach of the order, the tenancy terminated at the moment of the breach. That accordingly the wife's tenancy of the dwelling house had terminated in September 1985, when she first failed to make the payment due, and thus no secure tenancy existed capable of being transferred to the applicant under the provisions of the Matrimonial Homes Act. So the question arose a little indirectly, not on the tenants or former tenants application, former tenants exist, but indeed on the application of a spouse. The order that was made in that case appears at page 1428 of the report between letters E and G. And as Lord Justice Russell observes just before extracting the terms of the order, in the last sentence between D and E, he says that the order was in a form to be found at N28 of the prescribed form to the county court, and gives the reference, and then says the order so far as material reads. And as the members of the court will appreciate, the wording of the order is in the same template of form N28 as that used in Mr. Alan Austin's case. However, in this case, there was use of the requirement for payment of current rent. After giving the address of the premises in relation to which the order for possession was made, the order continues in its fourth line, and that the plaintiff do recover against the defendant the sum of 498.82 for arrears of rent, together with the sum representing costs. It's ordered that the judgment for possession shall not be enforced for 28 days in any event, and for so long thereafter as the defendant punctually pays the plaintiff or his agent the arrears of rent and costs by instalments of £10 a week in addition to the current rent. I emphasise those words, and also that the judgment shall cease to be enforceable when the arrears of rent and costs referred to above are satisfied. As Lord Justice Russell then observes, it is to be observed that on the face of the order it does not purport to terminate the tenancy. The tenancy, in my judgment, plainly continues and is recognised by the order as continuing. The judgment for possession, however, is suspended so long as the current rent is paid in addition to the arrears. If that were not the true interpretation of the order, then plainly the words "the current rent," to which I have adverted, would not appear as they do. So, that was the interpretation then by the Court of Appeal of an order in the template form N28, that the tenancy continued and the judgment for possession itself was suspended so long as the current rent was being paid in addition to the arrears. What then happened, as we see from the next following paragraph, is that the Court of Appeal went on to hold that the tenancy determined on breach. At letter H, Lord Justice Russell says, Mrs. Thompson did not comply with the terms of that order. In August 1985, we're told that she left the dwelling as a result of matrimonial problems. She left taking her child with her, indicated local authority no prospect of reconciliation, they properly advised her to receive assistance. By September 1985, it's acknowledged on all sides Mrs. Thompson had again permitted arrears of rent to accumulate and was in breach of the order obtained against her in the county court. When she left the matrimonial home, the applicant remained. The rent was paid by DHSS. None of the arrears was paid after her departure. And then the factual situation is then described. The question that the court was addressing at that juncture is set out at 1429 letter F. In this appeal, therefore, the question arises whether there was on the 5th of February 1986, when the husband applied, an extant secure tenancy which could be transferred. So, yea or nay, was the tenancy still on foot? In order to answer that question, Lord Justice Russell looked again at the statute, and in particular section 82.2, which he set out at the foot of page 1429. He was then shown a Rent Act case of Sherrin and Brand, which were advanced by counsel for the husband between D&E as supporting the contention that the tenancy had not come to an end, and he rejected that submission on page 1430 between letters F and G. He describes his holding as this, just above letter F. What I think is more important and indeed crucial is that Sherrin's case was dealing with an entirely different code of legislation, namely the Rent Acts, to that with which this case is concerned, namely the Housing Act 1985. And in particular, in the instant case, the court has the advantage of the statutory provision to which I earlier referred, namely section 82.2, which seeks to define the date when a tenancy is to come to an end. Accordingly, I'm of the opinion the court is free to distinguish Sherrin and Brand both on facts and law. He then, between G and H, sets out section 82.2 again. He reverts to the terms of the order at letter H, and right the penultimate line on the page, he says, in my judgment, once the defendant in proceedings of this kind, where there is a suspended order for possession, ceases to comply with the conditions of the order, namely the punctual payment of the current rent and arrears, and there is a breach of the terms of the order, the tenancy, whatever it may be, from that moment comes to an end. I perhaps ought to just explain the words whatever it may be, because one of the issues in the case was whether the tenancy could still be a secure tenancy, given that the tenant had left. But Lord Justice Russell is clear that whether it's secure or insecure, at the moment of breach, it came to an end. That is made clear on page 1431 at letter D, where in mid-paragraph he says, whatever the nature of the tenancy, in my judgment it came to an end on the 5th of September 1985, when the wife first breached the terms of the order.
But the landlord wouldn't have been allowed to send the bailiffs in the moment that happened, would they?
The landlord administratively applies for a warrant,
Exactly,
which is in fact exactly what happened in this case.
Yeah.
But the court staff simply need to be told yea or nay, is there non-compliance with the order? Indeed, they're not told that, it's simply filling in of a form. So the form is handed over the counter and then an appointment is booked with the bailiffs to attend. So when my lady says they couldn't have applied for a warrant... Well,
No, I didn't say that.
I'm sorry, my lady.
No, I said they couldn't have turned up with the bailiffs on the day that the rent wasn't paid. They'd have had to have gone to the court and got a warrant.
Yes, my lady,
They couldn't have evicted on that day.
No, they couldn't have evicted on that day unless the position at the court was such that on that day they filled in an application and the bailiff said we've got nothing to do with it.
If they'd managed to go round to the court, that's the point I'm making.
Yes.
They had to do something which involved the court in order to give them the right physically to obtain possession of the flat. This is a point in your favour, Mr. Luke.
I gather that, my lady, and I'm very grateful for that and any other points in my favour. My lady, I'm only anxious to take points in my favour which are
Absolutely.
substantial
Yes.
and
Yeah.
correct. And if I may respectfully say so, my lady's correct in both respects. The landlord is not able in this class of case, that is to say where order for possession has been obtained in respect of residential premises, to go in on the date, if there is a date in the possession order, or as in this case, on the date on which there is breach of the terms of the order. It is necessary for the application to be made under what is still County Court Order 26 for there to be execution of the order, and that is by warrant of possession, and a warrant of possession is obtained only on application. In the High Court, such an application requires judicial consideration, but in the County Court, as in this case, it's entirely administrative.
Ministerial.
Could I ask you, right at the end of his judgment, on page 1432, Lord Justice Russell makes some remarks about section 85(5).
Yes, my Lord, yes.
Which, are they right? It seems a very restrictive interpretation of the subsection.
Well, I had intended to put it in rather more measured terms.
You were coming to that.
Well, my Lord, I'll deal with it immediately.
Right.
My respectful submission, it's plainly wrong. Section 85(5) contemplates the precise situation in which Mr. Thompson found himself.
But that's what I thought, yes.
Yes, but this court, in that the Court of Appeal in that case, appears to have held that because the tenancy had ended, there was nothing further in relation to which he continued to have a matrimonial right. But that seems to fly against the closing words of the subsection, which are that the rights are not affected by the termination of the tenancy.
Yes.
It does seem a most extraordinary finding, if I may respectfully say so. And,
I mean, it seems to deprive section 85(5) of effect in almost any situation you can think of.
Well, yes, my Lord, and even more starkly than that, 85(5) is there precisely to deal with what had been the position in law before. That is to say, if an order had determined the tenancy, then there were no matrimonial rights for the spouse, and section 85(5) specifically made provision for what you might have thought would be Mr. Thompson's exact circumstances.
That's on the basis that the previous part of the decision is correct, which you're now challenging.
Well, indeed, my lady, yes.
So what do you say, if you're right about your main argument, what was 85(5) therefore?
85(5), my lady, was part of an attempt to address across all three statutory regimes the particular problem of a tenancy having ended in a situation where a spouse had matrimonial home rights. So an equivalent provision was introduced into the Rent Act extended discretion, into the Housing Act extended discretion, and I believe when eventually enacted into the Housing Act 1988. As Lord Neuberger was subsequently to describe in this court's, the House of Lords judgment in Knowsley and White, this was simply an aspect of torrential drafting.
Of what drafting?
Torrential drafting.
Torrential drafting.
Yes, my Lord. It was, in fact, unnecessary
Yes.
If, as I now contend, on a true construction of these provisions, the tenancy is not ended
Yes.
by the possession order until execution is taken.
And that's why you say it's now been taken out.
Exactly the same, my Lord, yes. Now, it's said against me that it's now been taken out precisely because the position in relation to Section 82 has been clarified. I say that it was redundant in any event, it didn't need it. But insofar as it had any use, its use appears to have been removed altogether by the passage on page 1432, which appeared to deprive it of application to the very class of case to which it might be thought it ought to have been applied, had the first part of the decision, as my lady says, been correct.
When was 85(5) introduced? Was it introduced after the 80 Act and part of the consolidation in 85?
It may have been introduced in 1984, my lady. Sorry,
It was introduced after and as a result of the Matrimonial Homes Act, wasn't it?
It was introduced as a result of a decision in a case that I believe is called Penn and Dunn.
Pen and Dunn, that's it. Thank you. Yes. The Matrimonial Homes Act was 67, so...
Yes, my lady. And then 1983.
Yes.
If we go to the original enactment of the Housing Act 1980 for the extended grounds for possession, which are behind tab 41.
When was Penn and Dunn? That was in 19...
I have to tell you that, my lord.
Right, hold on, we'll find it. So this is tab 41, the 1980 Act.
Tab 41 is the 1980 Act, originally introducing secure tenancies.
which is the section we're concerned with?
Section 33 on page 28, my lord.
Yeah.
And it wasn't there.
And it wasn't there in the original.
Yeah. Yes, I see.
I had hoped that it might be clear when subsection 5 was added from looking at an even later version of the Act, which is behind tab 44, but unhelpfully the editorial note doesn't indicate statutory origin.
Well, perhaps in due course, at some adjournment, the gentleman just come into court behind you who may be able to give you the answer.
Very much obliged, my lady. Thank you. My lady, I was suggesting that the court might find some assistance from the provision behind tab 44, where there is set out section 85 in an amended version prior to, as it were, the repeal of 5 and 5A, but sadly it doesn't indicate when 5 was imported. I suspect 1984, but I shall have to check over the adjournment with the assistance of the person to whom my lady has kindly directed my attention.
Right.
Well, the effects of Thompson and Elmbridge were immediately apparent. They were firstly that an order in the template form N28 was to be treated as an order suspending possession rather than suspending execution. And secondly, that non-compliance with the terms of the suspension thereupon determined the tenancy. This very rapidly produced a situation in which there were a large number of former tenants, because there is no requirement in the analysis of Lord Justice Russell that the breach be deliberate. Sadly, there would be a breach if the payment were a day late or a penny short, or if there had been an interruption of housing benefit or some other circumstance.
This looks as if it was we can see it was a two-judge court.
Yes,
It was an extemporary judgment by a two-judge court.
Yes, my lady. It was not possible to say whether it was, as it were, heard for a few hours on the first day and reserved overnight, but it does look indeed like an extemporary judgment of the two-judge division. And indeed, as we shall see it in a moment, it was the practice of the Court of Appeal then to have counsel tenancy cases, as it were, generally heard before two-judge courts. Yes. We shall see, indeed, in the next case to which I'll take this court, that happening again.
And but because it's one weekly law reports, we don't have the argument either.
We don't.
So we don't know.
No. So the best we can do as to the argument is from the terms of Lord Justice Russell's judgment. May I take a slight diversionary course in order to pick up on the observation Lady Hale first put to me about the correct reading of the order. Could we please go to Greenwich and Regan, which is at volume 1, tab 10. Greenwich and Regan is a judgment given 10 years later by the Court of Appeal. Thompson and Elmbridge was 1986, Greenwich and Regan is 1996, volume 1, tab 10. This is another decision of a two Lord Justice division of the Court of Appeal, and again an extemporary judgment. That case, I ought to say just a word about it, a little extraordinary perhaps. In that case, there was what would now be called a suspended possession order. There was breach, and it suited the former tenant to say that the breach had determined the former tenancy. The order for possession is set out in Lord Justice Millett's judgment at page 471. And it was a possession order made in 1989. It was, therefore, in the same template as that made in Mr. Alan Austin's case. It was submitted by Regan, in that case, that the order had ended the tenancy on breach. That appears from page 473 the last full paragraph on that page. Accordingly, it was submitted the original secure tenancy ended on 4th September 1989 when the defendant first committed a breach of the conditions on which the order was suspended. Lord Justice Millett then considers the operation of sections 82 to 85 in terms which we'll revisit in a moment because they're considered by the House of Lords in Burroughs and Brent. But can I go straight to page 476 to pick up this point, having been raised by my lady this morning? The centre paragraph on page 476 says this: I've read the terms of the order in the present case. Literally construed, they would appear to bring the tenancy to an end almost immediately, and only to suspend or stay the enforcement of the order. But the order is in the same form as that which was considered by this court in Thompson and Elmbridge. Despite the infelicity of the language of an order of this kind, it was not there treated as an order for immediate possession coupled with a stay of execution. On the contrary, it was treated as an order requiring the delivery of possession to be postponed in the first instance for 28 days, and thereafter until there was a breach of conditions of the order. As a result, the court held that the tenancy came to an end at the date of the first breach of the conditions. This may have been a generous interpretation of the order, but it was necessary to avoid the creation of a status of irremovability, unsupported by the existence of any tenancy, somewhat akin to the statutory tenancy under the Rent Acts, but which is inconsistent with the machinery and security provided by the Act, and in particular with the provisions of section 85 and 85.4, under which the rescission or discharge of the order is to leave the tenant in possession under his original tenancy and act as a tenant at sufferance who cannot be evicted. It is that passage in relation to generous interpretation of the N28 that I thought it right to take the court in the light of the question my lady put to me earlier. On the face of it, therefore, Lord Justice Millett, like my lady, would take the order first impression to be an order for immediate possession coupled with a stay of execution. That may have been a generous interpretation, says Lord Millett, but that's what we've been doing for the last 10 years, and we'll continue in that way. The big bang change came when the template order was reformed and restructured to include a date on which possession was to be given. I'll come back in due course, if I may, to Regan in relation to section 85, but I wish, if I may, to stay with the key question of whether Thompson and Elmbridge was correctly decided as to the tenancy ending on breach. And the next case to consider is Burroughs and Brent, a decision of their Lordship's House, indeed delivered 6 months after the Court of Appeal had considered Greenwich and Reagan. Burroughs and Brent is at volume 1, tab 4.
I mean, the case we just looked at Burroughs and Brent in the Court of Appeal and refers to it as a...
Indeed it did, my lord. And so the sequence is Burroughs and Brent Court of Appeal, Greenwich and Reagan Court of Appeal, then Burroughs and Brent in the House of Lords. And that's why the House of Lords were able to refer to Greenwich and Reagan in their speeches. My lords and my lady will recall that Burroughs and Brent was in fact an outright possession order case. It was not a case in which there was postponement or conditionality. The order was treated by both parties as terminating the tenancy, and Ms. Burroughs wished to advance the proposition that she had become a tenant under a new and subsequent agreement with the Council. So the question for the House at page 1450, at letter B in the speech of Lord Brown-Wilkinson, the question, he says at the end of that paragraph, is whether such an agreement between former landlord and former tenant operates so as to create a new tenancy which can only be terminated if the landlord obtains a further order from the court. As Lord Newburgh was to subsequently observe in exchanges in Knowsley and White, it suited both parties in Burroughs and Brent to start from the proposition that the possession order had ended the tenancy. Lord Brown-Wilkinson, however, in his speech sets out the statutory scheme, first the factual background on page 1450, then on page 1451, the statutory provisions. It is right to draw attention to the fact, against myself, that on page 1451 at letters D to E, he sets out section 82, including section 82.2, and he says at letter E, it is important to note that the secure tenancy ends not on the date on which possession is in fact given up, but on the date on which the order requires the defendant to give up possession. That appears to be flat contrary to the argument I am now pursuing, but as I shall indicate in submissions on this point, the contrary was not argued. Indeed, it suited both parties to advance that proposition. He then sets out sections 84 and 85, and on page 1452, his speech at the top of that page starts by setting out the argument for Ms. Burrows. And we can see that in line 4, Ms. Burrows was arguing that by virtue of section 82.2, her original secure tenancy had terminated on the date in the possession order, that is to say the 12th of February 1992. So not only suit her purpose, but that was the argument she was advancing. In the Court of Appeal, the counsel had taken the position described in letters on the same page, 1452, between letters F and G, but abandoned that position in the light of Greenwich and Reagan, as we see from the bottom of page 1452. The argument advanced to the House by the counsel in Burrows is set out in the series of propositions at the foot of page 1452. And the first proposition is that although under section 82.2 the original tenancy came to an end on the 12th of February, being the date fixed by the order, that was not necessarily the final position. So the submission of both parties was that the tenancy had ended on the date stated in the possession order. Having set out the analysis of section 85, the extended discretion, then offered by the counsel at paragraphs 3, 4, 5 and 6 over the page, Lord Brown-Wilkinson at letter E opens the paragraph with, I accept this analysis of the effect of section 85, which is derived from the judgment of Lord Justice Millett in Greenwich and Reagan, and he sets out the facts of that case. He says at letter F, the tenant in that case sought a stay of execution. He submitted that the old tenancy had come to an end when he failed to comply with the conditions imposed by the order. See Thompson and Elmbridge. May I just pause there, my lords and my lady, because it may be said that Lord Brown-Wilkinson is approving Thompson and Elmbridge, since that's the only reference he makes to the decision in his speech. As I hope is tolerably clear, what he was there doing is reproducing what the tenant argued in Greenwich and Reagan.
Well, I think that's clear from that sentence and also the following one, isn't it? It's the submissions.
Indeed, my lord. That's right. My lord, the speech continues with an analysis of the position in Reagan and the view of Lord Brown-Wilkinson in relation to it. There are some passages which I ought to go to in page 1454. Perhaps more sensible to start at the foot of 1453, letter H, penultimate line. They, that is to say the Court of Appeal in Reagan, distinguished the decision in the present case on the ground that they were dealing with a suspended conditional order of the court, whereas in the instant case there is an immediate unconditional order for possession. One factor which weighed heavily with the Court of Appeal in Reagan's case, to which I also attach importance, is the practical effect of the decision under appeal, i.e. any consensual variation of an order for possession produces a new secure tenancy or licence. I do rely on that passage, my lord, because Lord Brown-Wilkinson is himself identifying the importance of the practical effect of the decision when one's deciding how to approach it. He then explains that local authorities want to grant indulgences and so on, and that between letters C and D on the same page he says, yet the effect of the local authority agreeing to such a reduction will be that the tenant, whilst keeping up his payments at the agreed reduced rate, will be in breach of the conditions specified by the order at the higher rate. If so, his old tenancy will be terminated. there again reflecting, it must be said, what Thompson and Elmbridge had decided, although not expressly dealing with that point. Between letters E and F, again on the practicability point, he says, I find it impossible to believe that Parliament intended to produce such an unreasonable regime, penalising sensible arrangements out of court and requiring repeated applications to an already overstretched court system. Now, although that is said in a different context, we would respectfully say, here, it is impossible to believe that Parliament contemplated the chaos in relation to tolerated trespassers which Thompson and Elmbridge produced. Lord Brown-Wilkinson then goes on from letter F to offer the correct legal analysis of the statutory provisions. And at letter H, the last paragraph on the page, he says this: a secure tenancy protected by Part 4 of the Act is not like an ordinary tenancy. It can only be terminated by an order of the court, ordering possession to be given on a particular date or in a particular event. But even determination by order of the court is not final. Until the possession order is executed, the court can, by variation of its order, change the date on which possession is to be given, thereby revive a secure tenancy which has already been terminated. During the period between the date specified by the order for the giving of possession and the date on which the order is executed, there is a period of limbo. The old tenancy is gone, but may yet be revived by a further order of the court, varying the date for possession. If the parties reach an agreement as to the continued occupation of the premises by the tenant during that limbo period, what is the intention to be imputed? In my judgment, little guidance from the cases where a tenant holds over in relation to the ordinary tenancy. The position in relation to secure tenancies is sui generis. In my judgment, the agreement can and should take effect in the way the parties intend. An agreement by the landlord so that upon the tenant complying with the agreed conditions, the landlord will forbear from executing the order, i.e. from taking the step which would finally put to an end the tenant's right to apply to the court for an order reviving the tenancy. If I may say so, Lord Brown-Wilkinson is there struggling, as practitioners have had to struggle, with the language. It is not indeed, if this description of position is right, the landlord and the tenant who are agreeing. It is the former landlord and the former tenant who are agreeing about execution or otherwise of the order. It is at the end of that paragraph, between letters C and D, that he says it is fair to characterise the former tenant as a trespasser whom the landlord has agreed not to evict, a tolerated trespasser, pending either the revival of the old tenancy or the breach of the agreed conditions. And thus, once the effect of Section 85 is appreciated, the absurdities which led to the Court of Appeal not to accept that Miss Burrows could be a tolerated trespasser disappear. Technically, the old secure tenancy is, during the limbo period, no longer in existence. So in those circumstances, both parties having asserted that the tenancy had ended, that position is accepted by the House, but the House decides that the agreement for conditional retention of occupation is exactly that. Miss Burrows is to continue on terms as a trespasser in the property. Lord Jauncey then gives a separate speech, which also forms part of the majority, given that Lord Griffiths and Lord Stane expressly agree with him. He sets out between letters E and F on page 1456, section 82.2, and he adds the following between letters F and G. This provision, that is to say, 82.2, is mandatory, with the result that occupation by the tenant after the date specified in the order ceases to be attributable to the original secure tenancy. And of course he was dealing with an order which did include a date. He does mention Thompson and Elmbridge over the page 1457 between letters D and D, wherein describing section 85 and its effect, he says between D and E, if during the initial proceedings the court makes an order but postpones the date of possession, the tenancy will not be terminated under section 82.2 until any condition imposed under subsection 3 has been breached by the tenant, Thompson and Elmbridge. Now, he's not there setting out any argument, and it must be taken to that extent that he is there approving Thompson and Elmbridge. He then continues, the court's power to make an order postponing the date for possession is not restricted to exercise on first application, but may be exercised on the application of either party at any time, prior to the execution of the order. He then, from letters F to H, pays attention to the use of the term mean profits in subsection 3A as being the liability of the person once their tenancy has determined in respect of payment for the premises. And it's in that context that he adopts the terminology tolerated trespasser between letters A and B on page 1458. Before leaving his speech, however, may I take this court to the last paragraph on page 1459, where he looks at the policy of the legislation. He says, "My Lords, I agree with Mr. Neuberger that the impact of section 82.2 cannot be altered by agreement between the parties, and the impact is the impact he's described. However, for the reasons which I have already elaborated, that subsection cannot be looked at in isolation from the other sections, in particular section 85. The whole scheme of that part is to afford protection to the secure tenant, and that is achieved in section 85 by conferring on the court flexible powers to continue an existing secure tenancy, to revive a determined secure tenancy, or to create a state of statutory limbo which will afford to a defaulting tenant an opportunity to have restored to him all the benefits of the secure tenancy when he has complied with stipulated conditions. Parliament cannot have intended to penalise a landlord who acted within the spirit of the Act by granting indulgences." And there's further reference to the spirit of the relevant statutory provisions at letter F. My Lord, my Lady, we rely on the terms of that paragraph as indicating, although it upholds a description of the statutory scheme which for present purposes is against us, an important attention to what the scheme is about, that is the protection of the secure tenant and the flexible powers available under section 85. It is right to say that the decision of the House in Burroughs and Brent was treated as having approved Thompson and Elmbridge, and therefore as having upheld the proposition that an order in Form N28 operates to determine the tenancy on first breach. Secondly, it was treated as deciding that such an occupier, a former tenant, remains in occupation in a form of statutory limbo, not qua tenant and not liable to pay rent, but as a tolerated trespasser liable to pay mean profits. Furthermore, the House decided that the limbo situation continued even if execution of the order was stayed on terms which were complied with. We see that from Lord Jauncey at page 1457, letter F. Where he observes, in the paragraph starting, however, whereas an order postponing the date of possession necessarily affects the operation of section 82.2, an order staying or suspending the execution of an order for possession on a stated date has no effect on the operation of that subsection, but merely postpones execution, so long as the conditions of the suspension are complied with. So we had, by virtue of this decision, tolerated trespassers in the sense that the landlord was prepared to tolerate their trespass, and we had tolerated trespassers who were tolerated on terms set by the court. That is to say, the landlord was told, you cannot execute a warrant against this person, provided they pay X and Y, but if they pay X and Y, they do not get their tenancy back.
What's his point on section 85.2a? You see, just below letter G, those words, he says, are in my view particularly significant since they show the Act contemplates the court requiring post-termination payments made by an occupier which are of a nature wholly inconsistent with the existence of any tenancy in his or her favour.
Yes,
What's he getting at there?
He's there, I think, referring to the fact that in section 85.3, that is to say, the conditions that might be imposed,
yes,
whether on adjournment, stay, suspension or postponement, they include, as we see from the top of page 1457 most conveniently, payments in respect of occupation after the termination of the tenancy, bracket, means profits.
Oh.
And I think what Lord Jauncey is there saying is that there are two options for a judge who's suspending execution, potentially. They are to suspend execution on payment of current rent, or to suspend execution on payment of mean profits.
Yes.
And if the tenancy has gone,
Yes.
then the appropriate order is suspended on mean profits plus X pound per week
Yes.
off the arrears.
And the reference to mean profits has gone now, along with the other bits and pieces.
Yes, it has, my Lord, and it was particularly relied on in the construction of the equivalent position for assured tenants in the Knowsley case, to which I'll shortly come. It was not surprisingly said by counsel for the landlord in that case that the fact that there is reference in section 85.3 to payments after termination of the tenancy suggests that a possession order terminates the tenancy before execution of the order.
Yes.
And one can see that there is something in that.
So, I mean, he's referring to that, and one could say that is reinforcing the narrative which he gave earlier, in which he appears to accept Thompson and Knowsley.
Indeed, my Lord, and I don't shy from that. It appears to be the position taken by Lord Jauncey more directly than Lord Brown-Wilkinson, who merely, as it were, cites it as part of the argument from the case of Regan. Lord Jauncey's view is quite clear, that the stay or execution follows the coming into effect of the possession order, which itself has determined the tenancy.
Did Lord Brown-Wilkinson make the same point? I didn't pick that up when you were going through it.
I'm sorry, my Lord, I may have taken a little too quickly to have done that. We do see that in the description of the council's case at subparagraph 4 in brackets on page 1453.
Oh, yes, I see. So that's narrating the argument.
Yes, but it's right to say that he accepts that
the
analysis.
Yes. Thank you.
My Lords, I was seeking to describe what the position was immediately after Burrows and Brent. As I've indicated, it was taken as endorsing Thompson and Elmbridge in the view that breach of the terms of an N28 would lead to the termination thereupon of the tenancy. Secondly, it was taken as deciding that thereafter the occupier remains in a legal limbo, conveniently described with the label tolerated trespass, where there is no liability to pay rent, only a liability to pay mean profits, which might be enforced by terms under section 85.3a. And thirdly, I was indicating that that remained the position even if execution was suspended by the court, rather than, as it were, by agreement between the parties, as Lord Jauncey indicated at 1457F. Further, the House decided that you could only get your former tenancy back by a successful application under section 85. In particular, section 85.2a, I beg your pardon, 85.2b, postponement of the date, or section 85.4, that is to say, the discharge of the order. My Lords and my Lady, although that was well appreciated or thought to be the effect by most practising in this field after Burrows and Brent, it's a sad fact that almost all orders for stay or execution of possession made by district judges thereafter provided for payment of current rent plus an amount off the arrears. That's just how these things happened. The consequences of the upholding of Thompson and Elmbridge were that there was the prospect of another dozen years from 1996 onwards of persons falling into the legal limbo because they did not comply with the conditions of their orders. As Lord Mance observed in Knowsley at paragraph 15, secure tenants often fail to comply with the conditions, whether deliberately or innocently or whatever. There were huge numbers of persons losing their tenancies, apparently, pursuant to the structure of section 82 to 85 as decided by the Court of Appeal in Thompson and by the House of Lords in Burroughs and Brent. Lords and Lady, I'm not going to invite the Court to consider at great length what those problems were, but can I briefly go to the discussion in Hassan as to the trigger for change? Hassan is in volume 1 at tab 3. Hassan is May 2006 reserved judgment of a three-Lord Justice division of the Court of Appeal. What was done in Bristol City Council and Hassan was that a solicitor came up with the idea of inviting the court to make a possession order which didn't include a date. And if the court could do that, then it could avoid the Burroughs and Brent, Thompson and Elmbridge difficulty. The judges concerned decided that a possession order had to have a date, and the issue came on appeal to the Court of Appeal. Ultimately, the Court of Appeal decided that a possession order didn't need to have a date and approved a template of an order without a date. But may I just take the Court into the judgment for relevant parts of the history. Paragraph 26 on page 2591. Lord Justice Brooke is at paragraph 26, setting out part of the history, and I've picked it up at paragraph 26 because that's where he deals with Thompson and Elmbridge. He records at 26, Thompson and Elmbridge led to a certain amount of disquiet, and he refers to some articles. However, he says, the revised version of Form 28, N28 that was issued in 1993 did not adopt the suggestion made in the articles. Instead, it was in these, quotes, user-friendly terms. Paragraph 1, the court has decided that unless you make the payments as set out in para 2, you must give the plaintiff possession of the premises on, brackets, insert date. And it was in 1993, therefore, that the Form N28 was changed from the form in Mr. Alan Austin's case, that is to say, simply adjudge that you have possession, to you must give the plaintiff possession on such and such a date. After setting out the terms of the new N28, Lord Justice Brooke then concludes that paragraph by saying this was followed by the 2001 revision, and the 2001 revision is set out on page 2597. And that provides in the first paragraph, at the top of the page, the defendant gives the claimant possession of the property on or before, and again, a space for the date to be entered. If we go back into the main text at paragraph 27 on page 2591, we can see what then happened. Paragraph 27, although the 1993 version of Form N28 could reasonably be interpreted as postponing possession after the date mentioned in paragraph 1, so long as the tenant complied with the conditions set out in the order. So if we just look at that in the terms set out in the immediately preceding paragraph, you must pay the plaintiff in total the sum of by instalments in addition to current rent. When you've paid the total amount, the plaintiff will not be able to take steps. It's that the Court of Appeal is saying could be interpreted. He then continues, the stark language of the 2001 revision permitted no such interpretation. Possession was postponed until the date fixed in para 1, and the tenancy would then come to an end through the operation of 82.2. Thereafter, execution of the order would be suspended so long as the conditions set out in the order were complied with. See the judgment of Sir Andrew Morritt in Harlow District Council and Hall. And it was, as my Lord Simon Brown was observing a moment ago, the decision in Harlow and Hall that the new template Form N28 appended to the judgment in Bristol and Hassan wasn't in fact a suspended order but was an outright order that transmitted a whole new species of tolerated trespassers into the equation. They were people who were complying with the conditions but were nevertheless non-tenants. produced a situation in which, as a result of the combined effect of Thompson, Burroughs and the template introduced in 2001, we now had hundreds of thousands of people living in the social rented sector who were in the limbo described in Burroughs and Brent. The Court of Appeal in Hassan, I'm sorry I put it away myself without intending to, paragraphs 33 to 34, this is behind tab 3, set out some of the practical difficulties that had arisen in relation to the management of these hundreds of thousands of people. At paragraph 34, Lord Justice Brooke kindly reproduced a list of 9 reasons why the status of tolerated trespasser was unsatisfactory for both parties. The first reason was that the occupier couldn't enforce any covenant to repair or any other contractual term of the tenancy. That was equally true of any statutory rights which were contingent on tenant status, such as the right to buy, mutual exchange, assign. 2, not clear whether he had a right to occupy by virtue of any enactment for the purposes of the Family Law Act. 3, no statutory rights of succession if he wished to die. 4, an application to resurrect previous joint tenancy by postponing the date of possession can only be made under 85.2 if both the former joint tenants agree, and this may give rise to practical difficulties if one of them cannot be traced. 5, if the tenant clears the arrears before making the 85 application, will have no standing to reinstate the tenancy. That was as a result of a decision of the Court of Appeal in Marshall. 6, the landlord cannot enforce any covenant with regard to the former tenant's behaviour or any other covenant. 7, the statutory framework for increasing the rent payable does not apply. 8, it has now been established that a secure tenancy would be lost by breach of the conditions in a possession order and only revive if there is an application pursuant to section 85, see Marshall and Bradford and Lambeth and O'Kane. 9, problems arise in respect of stock transfer between a local authority and a registered social landlord because it's only the rights of tenants which survive the transfer. And that caused the last particular problems because over 1 million homes were transferred from councils to housing associations, many of which were seemingly occupied by people in limbo. As the Court of Appeal noted at paragraph 37, the Law Commission had by this time become involved in seeking a solution, and as we see at paragraphs 36 and 37, the Law Commission's proposal was for new legislation, and indeed the Law Commission set out a complete replacement renting homes bill attached to their report, which would deal with all forms of tenure and avoid this problem. However, that has not been taken forward. My Lords and my Lady, I appreciate, however, that despite the long list of things that are wrong with the limbo status and tolerated trespass status, it's not enough for me to show this court that the decisions of Thompson and Elmbridge and Burroughs of Brent were problematic in their application. I've got to show that Thompson was wrong and Burroughs was wrong to approve Thompson, whether that approval was direct in Lord Chauncey's speech or indirect in the speech of Lord Brown-Wilkinson. Everything turns on the proper construction of section 82.2. Do those words mean that the tenancy ends on the date stated in the order? If the court wishes to have the words again, they're behind tab 42 in bundle 4.
Yes. These are the dates, the words that Lord Newberger picks up.
Indeed, my Lord, yes.
I mean, are we going to look at that, Knowsley?
Yeah, next case, my Lord.
Yeah.
Okay.
Right.
It all goes to section 82.2, and the question is, does section 82.2 mean that the tenancy ends on the date stated in the order for the giving of possession, or, as the Court of Appeal decided in Thompson, the breach of any condition relating to the giving of possession, or does it mean, as we contend, the date on which possession is given or taken in pursuance of the possession order? Before coming to Knowsley, may I indicate why we say it is wrong to construe it as it was construed in Thompson and in Burroughs. The first reason is that it is a necessary consequence that we have a substantial application of a limbo situation. If section...
Could you just repeat that?
Yes, my Lord. And the necessary consequence of the Thompson and Elbridge construction of 82.2 is that we must have in the housing stock a large number of limbo occupiers.
And these include people who have actually obeyed the order.
They include people who have obeyed the order, my lady, particularly since the order was amended in 2001. No court has yet addressed the position of those who complied with the old-style orders. But yes, my lady, it includes what are referred to as innocent tolerated trespassers. Innocent in the sense that they have complied, or innocent in the sense that their non-compliance is accidental or has been caused by a third party.
This is an additional factor to the ones listed, I think, in Hassan. Is that not right? Because I had the impression that the innocents weren't actually contemplated in that list. Perhaps it doesn't matter.
No, my Lord, I'm sorry if that wasn't clear, and perhaps I took Hassan too quickly.
Yes.
No, my Lord, by Hassan it had become clear that since 2001 a huge phalanx of innocent tolerated trespassers...
I understand the timing, but it doesn't stand off the page as one of the things you listed.
No, it doesn't.
I mean, I can see the force of putting it in as a relevant factor.
Yes, my Lord.
Since 2001.
Indeed, my Lord. But even before 2001, the effect of Thompson and Elmbridge was that tenants were becoming innocent tolerated trespassers simply by their inability to comply with the terms of an N28. If I may just add this matter, the most common form of N28 was that the occupier pay current rent plus a fixed amount towards the arrears. And the form N28 required punctually pay. The fixed amount for most council tenants was the amount which could be lawfully deducted from their social security benefits each week and paid to the landlord. Usually a very small sum, £2 or £3 odd a week. Thousands of such orders were made. The difficulty was that the Department of Social Security only paid the instalments 4 weekly in arrears. So all those people became tolerated trespassers simply because the payments from the Department of Social Security were made not weekly, but 4 weekly.
And nobody told the county courts that so that they could draft orders which actually fitted in with most people's lives.
Well, my lady, sadly, the vast majority of these tenants are not represented at the possession hearings, so these points tend to come up ex post facto. But it is right to say that in the second of the two articles which I mentioned in Hassan, my lady will have seen that the authors were prospective.
Well, one of them was Nick Madge, yes.
Yes, my lady. He suggested a formal order in that article which was adopted, it is right to say with credit, by some county courts and some judges, and was not adopted by others. And the effect was that the N28s continued to be made. Worse still, when information technology was introduced into the county court, it became impossible to make possession orders other than in the prescribed forms because the computers couldn't generate them. So one had the happen chance of finding oneself before a district judge in West London who printed his own orders and sealed them, simply because it was the only way of bypassing a system which would produce impossible orders. Well, I only make that diversion into that story of the history in order to deal with the question of innocence.
Yes.
There were both people who were complying, who were becoming tolerated trespassers, and there were others who were not complying for quite innocent reasons, such as those I've mentioned. And that, of course, assumes that the housing benefit system, which is paying the current rent, is in fact operating properly as well. And I hardly need to develop that aspect. So the first consequence of the Thompson and Elmbridge and Burroughs and Brent line was that it necessarily contemplates on that construction of section 82.2 numbers of, and we would say large numbers of, occupiers who will be rendered into a limbo existence. The second difficulty with section 82.2 is that it appears to be inconsistent with the statutory scheme. Firstly, I adopt again the first factor, that it produces, in a regime intended to protect tenants, a substantial cohort of non-tenants. But secondly, there are other indicia in the statute that section 82.2 was not intended to work in that way. And the most obvious one behind tab 42 that is in the 1985 Act as enacted, is in section 121, which is on page 62 of the Queen Printer's copy. Where at section 121, in relation to the right to buy, which is an important right of secure tenants, section 121, subsection 1 provides, the right to buy cannot be exercised if the tenant is obliged to give up possession of the dwelling house in pursuance of an order of the court, or will be so obliged at the date specified in the order. The first of those two alternatives envisages a tenant who is obliged to give up possession. But if the construction of section 82.2 adopted in Thompson and Elmbridge is right, there can't be such a person, because once you are obliged to give up possession, you are an ex-tenant.
So it all turns on the use of the word tenant.
It does.
Yeah.
But it's important in this context that it's there describing the exercise of a right which is available only to a secure tenant, that is to say, the right to buy. The third factor, which is important in considering whether the Thompson and Elmbridge construction of section 82.2 is correct or not, is that if it is correct, it produces an inconsistency with the other two major statutory regimes for the protection of occupiers. It's inconsistent with the Rent Act, because as we know, the statutory tenancy continues until the occupier actually leaves pursuant to the order, and it produces an inconsistency with assured tenancies, the other main regime, because the House of Lords has held that in the assured tenancy regime, the tenancy doesn't end until possession is actually given. One might say, well, so what? The other regimes apply to other classes of person. But that is not so. The assured tenancy regime, to which I'll come very briefly in a moment, the Housing Act 1988, applies to social housing as much as to private housing. The largest type of provider of social housing at the present time is a housing association. They are the major providers of social housing at present. There are more new lettings by housing associations than there are by local authorities. And housing associations will have within their stock two sorts of tenants: secure tenants, if the tenancy was granted before 1989, and assured tenants, if the tenancy was granted after 1989. If section 82.2 was correctly construed in Thompson and in Burroughs, the effect is to have limbo ex-secure tenants, but no possibility of limbo ex-assured tenants. And the fourth feature is that all three statutory regimes have the extended discretion set out in section 85 of the Act, 1985 Act, but replicated in virtually identical terms in the Rent Act 1977 and in the Housing Act 1988.
Could you possibly give us the section numbers without
Yes, my
actually
Lord. Rent Act 1977, section 100, Housing Act 1988, section 9. My Lords, it's against that background in relation to section 82.2 that I then invite this court to turn to the latest decision of their Lordship's House in Knowsley and White.
Before you go there,
Sorry.
just to be quite clear that I've got correctly what you say section 82.2 means. I noted you down as saying it means when possession is given or taken in pursuance of the order.
Yes, my Lord.
And I'm just wondering how that fits with the phrase on which the tenant is to give up possession, because you are asking us in effect to reorganise the language a little bit, aren't you?
I am, my Lord, a little, but the parliamentary draftsman drafting section 82.2 in 1985, or indeed his predecessor drafting the Housing Act of 1980, would have well known that possession is not to be given up to the landlord on the date stated in the order or on the happening of an event, because possession is given pursuant to the execution of the order by a warrant of possession. It is the last stage, as it were, and it is that last stage that we say is contemplated by the words is to give up possession in pursuance of the order.
In other words, he's not to give up possession until the order has been executed.
He's not required to give up possession until the order is to be executed. When the warrant is issued to him, he is given the date on which he must leave, and if he isn't out by that date, then the bailiff will on that date turn him out.
So he might be well advised to pack up his belongings in rather more orderly fashion and leave before the bailiffs arrive.
He might be, my lady, which is why I suggest that the correct construction of 82 is either possession is given or it is taken.
I thought that's what you meant.
Yes.
I mean, you could possibly say, could you, if it had been intended to mean what Thompson and so forth said, it should have finished, the tenancy ends on the date on which possession is ordered to be given.
My lord, there are different ways in which one might have written the subsection to give effect to what was decided in Thompson and Elmbridge. What we say about that is that that demonstrates that it wasn't the intention to produce the situation that Thompson and Elmbridge produced. Parliament never contemplated, in my respectful submission, that what would occur is that persons would remain in possession in a situation such as Mr. Alan Austin for 18 years after a possession order.
I follow that entirely, but I mean, if it had said what I suggested, the date on which possession is ordered to be given, then that would have been clearly against you, and how would you survive that?
Well, firstly, the difficulty would be that it wasn't fully against me because the order in Mr. Alan Austin's case didn't contain a date. So that an issue would then arise as to whether you would infer a date. And it may be partly that in light of that, when the forms were reconstructed in 1993 and 2001, a date was inserted. Thompson and Elmbridge, in fact, develops the language of Section 82 to be that the tenancy ends on the date on which the tenant is to give up possession, either if there is a date on the date specified in the order, or if there is a condition on breach of the condition.
And I'm sorry to take you, hold you back from going to Knowsley, but I'm just wondering what your position is about Section 85(3) and the reference to mean profits and subsection 5, and we know subsection 5A came in.
Yes.
Is it just simply you say, well, that was redundant, really? Is there any other explanation we can give for the presence of these provisions?
Yes, I can give an explanation, but that doesn't detract from my submission that they were redundant.
Yes.
The reason that they're there is that the draftsman of Section 85(5) imported the template from the Rent Act. Section 100 of the Rent Act 1977, which he was working from both in 1980 and in 1985, was in almost exactly the same rubric as what is now Section 85. It included mean profits, and it included, having been amended, the provisions in subsection 5, both of which were entirely redundant in the Rent Act context. You couldn't order mean profits to be paid by a statutory tenant because a statutory tenant was paying rent, and the possession order did not determine the statutory tenancy, and therefore subsection 5 was redundant. However, without perhaps sufficiently thinking that through in the context of the Housing Act 1985, exactly the same words were imported, and when Parliamentary Council came to draft Housing Act 1988 3 years later for assured tenants,
yes,
he again took the same template. So we ended up with 3 statutory regimes, in all of which, we respectfully submit, the words mean profits were redundant. Took Parliament a long time to get round to dealing with that, but that was the case, and that was held to be the case by the House of Lords in Knowsley.
Well, that's a useful introduction to Knowsley. And although it was there, the House of Lords wasn't deterred.
Well, if I may respectfully say so, it's a rather powerful point for my opponent in Knowsley, as will be recalled by this court. I was for an assured tenant in Knowsley, and my opponent's, one of my opponent's best point was that, well, the words mean profits and the reference to termination in the subsection 5 are in the assured tenancy regime must mean that the assured tenancy was determined. And that was dealt with by the House of Lords in relation to assured tenancies in the way that I'm inviting this court to deal with it in relation to secure tenancies.
Yes.
So you basically say about this point, these 2 provisions are redundant in both the other schemes, although they're there.
Yes, my lady.
And so why aren't they equally redundant in this?
Exactly so, my lady.
To which the answer given, right or wrong, is, well, they haven't got an 82.2 to contend with.
That's the distinguishing feature, my Lord, and I don't shy from that point at all, and that's the point to which I must come in the context of Knowsley and White.
Well, shall we look at Knowsley then?
But very much obliged, well, let's go to that if we may. Volume 2, tab 18.
Of course, it could be suggested they got something worse than 82.2 to contend with.
I'm sorry, my lady.
It might be suggested they had something worse than 82.2 to contend with,
Might be.
which is the underlying law that a notice to quit brought the tenancy to an end.
Yes, my lady, and that is right. The Rent Act regime...
So I don't want you to get ahead of
Yes,
it, but that's the point, isn't it?
Yes. We have Knowsley and White behind tab 18. As members of this court will appreciate, the Lordship's House heard 3 appeals in that session of hearings, Knowsley, Porter and Islington. It is Knowsley and White which raises the issue most acutely now for this court. I indicated in introducing the case a moment ago that I had appeared in that case for the assured tenant, and it is right to draw the court's attention to the fact, even though it be against myself, that on page 642 of the argument which is recorded in the appeal cases, I argued the exact reverse of the proposition that I now advance.
That wouldn't be the first time you've done
No,
that.
these things happen.
It would be, no it wouldn't, my lady, and I'm pleased to say it's still not going to happen that I'll do the same thing in one case, but in that case I was for an assured tenant, and it suited the assured tenant's argument to draw the distinction. So that my argument is recorded at page 642, letter B. In contrast with the 1988 Act, section 82.2 of the 85 Act expressly identifies when a periodic secure tenancy is to end, namely on the date on which the tenant is to give up possession in pursuance of the order. It is not correct to conclude that 82.2 is redundant if the effect of 82.1 of the 1985 Act, which is expressed in similar terms to section 5 of the 88 Act, is that the tenancy ends on the date specified in the order. Thompson and Elmbridge, Harlow and Hall. The decision in Thompson that the tenancy ends on breach of the term of the possession order is too long established to be departed from and can be circumvented. Bristol and Hassan and Leadenhall. By circumvention, I mean that devices had by that time been found to get round the practical problem caused by Thompson and Elmbridge.
So and circumvented by Hassan by simply not putting a date in.
Exactly so, my lord, yes. That was the device that had been developed by that stage. And a device, which I ought to just add to the history, eventually turned into a new prescribed form of order, the N28A, which didn't include a date. However, it was important to my case for that assured tenant to argue the case in the way I did on the basis of section 82.2. The question before their Lordship's House in the Knowsley case was yea or nay whether an assured tenancy ended on the date specified in the order or on breach of its conditions, just like as a secure tenancy has been held to do, or whether in fact an assured tenancy survived until execution of the order. Lord Newburger gives the leading speech, paragraph 28 of the report, page 657. Paragraph 28, he says this: these 3 appeals raise questions about the effect of suspended possession orders on the status and rights of secure tenants under the Housing Act 1985 and assured tenants under the Housing Act 1988. Against that introduction, he then sets out the relevant statutory regimes governing security of tenure. I don't invite the court to read through all those descriptions now, but I would draw attention to the common feature which he draws at paragraph 35. The protection afforded, he says, to protected, secure and assured tenants is effected through the medium of circumscribing the landlord's right to possession. That is the first of several common features between the 3 regimes, and that is that security of tenure is achieved by circumscribing the landlord's right of possession. He then draws attention to the common way in which rent arrears cases are dealt with at paragraph 37, and that is to say that in all three regimes, the landlord is required to make out a ground for possession and show that it is reasonable to have possession. Again, a common feature of the three. At paragraph 38, he draws attention to the fact that in all three regimes, the court is given very wide and flexible powers. In all three regimes, described as the extended discretion. And he lists those three provisions, section 100 of the Rent Act, 85 of the 85 Act, section 9 of the 1998 Act. He then reproduces those three sections at paragraphs 39, 40 and 41, and one can see immediately the great similarity between the wording of the three of them. A further common feature he draws attention to at paragraph 42 is that all three of those extended discretions contain subsections dealing with spouses and former spouses, indeed in the same way. However, it's right to say that at paragraph 46, having described the approach taken under the later Act, he does draw attention to the fact in the second part of paragraph 46 that the 1988 Act has no provision expressly stating when an assured tenancy subject to a possession order comes to an end. In other words, section 85 of the 1988 Act has no equivalent to section 82.2 of the 1985 Act. So he's there having set out a range of the common features of the substance of the three statutory schemes, does draw attention to that distinguishing feature. He returns, however, in paragraph 47, in describing common features, to the fact that all three regimes have provision for succession to the tenancy on death. What approach then to take to statutory construction in relation to these schemes? I do invite this court to adopt the approach set out by Lord Newburgh in paragraph 68, particularly the last sentence at the top of page 666. While normal principles of interpretation should not, of course, be jettisoned, the importance of the law in this field being substantially and procedurally clear and simple is cardinal. It is that approach I'm going to invite this court to apply, as his lordship applied it to assured tenancies, now to secure tenancies.
What does cardinal mean? Just short of being the Pope, or what?
I'm sorry, my lady. I'm sure as my lady is that what he was meaning there is that it's of prime importance.
Yes, I find it quite difficult to work out what it means. That's why I asked.
Sorry, my lady.
It was meant as a joke as well, but I was asking because you don't... Is it an overriding consideration, or is it a background consideration when one's trying to make sense of what Parliament has done, or what is it? Anyway, no matter. I don't find it easy to understand what cardinal means.
Yes.
Is he going further than Lord Porter?
Yeah.
Yes, my lady, and it's all my fault, I suppose, because, as you'll see by going back to my submission, I put him up to it. I can't recall whether I suggested cardinal or not, but I'm sure we can find out.
You might have said imperative, I suppose.
Might well have done.
But that's why I mentioned the Pope.
I mean, it's slightly hyperbolic. He's saying it's very important, and obviously
Yes.
it is.
Well, I think we can see your page 642 E and F.
Yes.
So it doesn't actually include the word cardinal. You're really basing yourself on Lord Porter, I think, aren't you?
Good.
Anyway, there we are. It's interesting.
Well, it may be difficult to follow or apply or to suggest what I mean by it, and that is where one is coming to construe social legislation. It's important to identify what the principle is that is sought to being achieved by the statute, which is to say the protection of occupation by tenants, and then to say, well, how should we approach the interpretation of that statute? Should we approach it as a strict property lawyer would, or should we approach it in a way which is intended to be applicable by social landlords and their social tenants? And I hope that Lord Newburgh is there suggesting that you take the latter course. You try and find an interpretation which is substantively clear and simple, and procedurally so also. It works, in other words. My Lords and my Lady, the question then posed for the House by Knowsley and White is set out as the header to paragraph 69. When does an assured tenancy subject to a possession order end? Note obviously not when does a secure tenancy subject to possession order end, because there wasn't a secure tenancy case before their Lordship's House in that series of 3 cases in which the issue arose. Although the other 2 cases were secure tenancy cases, the issue in that case, the issue in those 2 cases was not, as the issue is in the present case, what was the effect of section 82.2. There might have been such an appeal, but indeed that was compromised before the hearings. My learned friend suggests that it would have been an answer to the appeal in Hunnigan Green, and no doubt he will develop that in the course of his submissions on this case. Hunnigan Green, as the court will see, was about the right to buy and the effect of revival of a tenancy. The analysis then offered by Lord Neuberger at paragraph 69 onwards starts with the Rent Act provisions, which he deals with in paragraphs 69 and 70, setting the history of how the approach to statutory protection was dealt with under the Rent Act. And as this court well knows, under the Rent Act, the landlord was free to determine the contractual arrangement by notice to quit, as my lady has said, and then a statutory tenancy arose. But at paragraph 71, he indicates that the authorities suggest the position in relation to secure tenants under the 85 Act is rather different. And he refers to Thompson and Elmbridge and sets out a passage from the judgment of Lord Justice Russell. He says at 72 that the correctness of this decision was not challenged in the argument before the House in Burgesses, where the issue was whether the new tenancy created by agreement between the landlord and secure tenant against whom possession would have been made. As neither party challenged the reasoning in Thompson, there was no contention that a secure tenancy only ended when the order for possession was executed. It is fair, if it may be a little defensive, to add that it suited both parties to accept the conclusion in Thompson. However, both Lord Wilkinson and Lord Johnson expressly stated that Thompson was rightly decided. And I've already indicated that with respect to Lord Neuberger, that goes a little too far. Lord Brown-Wilkinson, certainly in the passage referred to, does not expressly say that Thompson was rightly decided. He is in the passage referred to, as I've indicated already, referring to the submissions of counsel in Reagan. At paragraph 73 of the speech, he refers to the subsequent application of the Thompson principle and the fact that there have been tens of thousands of cases subsequently in which the Thompson proposition has been applied. He then goes to the 1988 Act to deal with the assured tenancy regime, and he says at 76, leaving Burroughs, Thompson, Hall and Artesian on one side for the moment, I consider that on a fair and practical reading, the 1988 Act leads to the conclusion that an assured tenancy subject to possession order does not end until possession is delivered up. We'll come to his reasons in a moment, but it is again right to say at paragraph 77 that he draws attention to the fact that the 1988 Act has no express provision indicating when an assured tenancy subject to possession order ends, and he contrasts that with section 82.2. But may I take the court to the 3 reasons that Lord Neuberger gives for the conclusion that an assured tenancy does not end until possession is given up, because I shall respectfully suggest that all 3 reasons equally apply to the secure tenancy regime. His first reason at paragraphs 79, 80 and 81, I summarise in this way, that there is no provision in the statutory regime to address the status of those in the shadow of a possession order. What he's doing at paragraphs 79 to 81 is indicating that the statutory regime didn't contemplate people in limbo as a result of the possession order. Either they would be out or they would remain as tenants. He makes that point good by reference to what's happened in relation to secure tenancies. He shows that there would be tens of thousands of people in occupation for long periods, paragraph 80, and draws attention to the fact that, although it can be said that this is a similar situation for long leases that have been forfeit, until there's relief, they are, as it were, tenants in limbo, that itself is an archaic position. The proper application of the statute is that it is not intended that there will be people living in the shadow of possession order who are not tenants. At paragraph 82, his second reason, the paragraph starts secondly, is that the invention of tolerated trespassers, these people in limbo, has led to difficulties and uncertainties as to their rights and as to the obligation of the landlord. And he finds that and the difficulties he there describes inconsistent with the statutory regime. And his third reason, paragraph 85 onwards, is that there is this very broad extended discretion that applies across the three regimes. He deals in paragraph 87 with the mean profits point and the spouse point. And at paragraph 88 he says, in my judgment, section 100 and therefore section 9 contains more than one example of torrential drafting. Not only are the references to mean profits unnecessary, but stay and suspend are synonymous, as are discharge and rescind. Section 100 owes its origin to the 1923 Act. Accordingly, it must be construed bearing in mind that its origins are based on a provision enacted at a time when the drafting of the Rent Acts was not, as I have mentioned, noted for their clarity. Having therefore found that there are those three reasons for holding that an assured tenancy does not end until possession is delivered up, at paragraph 90, Lord Newburger says, it is now necessary to face up to the point that this means that the effect of a possession order under Part 1 of the 88 Act would be different from one under Part 4 of the 85 Act, as stated by this House in Burgesses. As already explained, there is a difference between the 85 and 88 Acts, in that the latter has no equivalent to the former's section 82.2, and it was the wording of that subsection on which Lord Justice Russell primarily rested his conclusion in Thompson, indeed on which Sir Andrew Morritt rested his conclusion in Hall. Accordingly, although it would obviously be sensible and convenient that the point at issue should be resolved in the same way under the two statutes, I do not consider that logic compels that result. However, it should be added that I strongly suspect that if the point had not been determined in Burroughs, I would have reached the same conclusion in relation to section 85 of the 1985 Act as that which I've reached in relation to section 9. There is a powerful case for saying that the date on which the tenant is to give up possession in pursuance of the order in section 82.2 of the 85 Act can and therefore should mean the date specified in the warrant of possession which is duly executed or acted on by the tenant. Furthermore, section 121 of the 1985 Act appears to me to be arguably inconsistent with the decisions in Thompson and in Hall, in that it expressly appears to assume that a tenant who is, as well as a tenant who will be, obliged to give up possession pursuant to a court order, would remain entitled to pursue the right to buy, and only a person is secure, a tenant, can have that right. Given that these arguments, and indeed the point now at issue, were not actually debated in Burroughs, should your lordships reconsider whether Thompson and Hall were rightly decided? When that question was raised with Mr. Luber, he replied with the apparent support of Mr. Underwood, Drabble and Arden that it was simply too late to take that course. Thompson had been assumed to be right, acted on in many tens of thousands of cases in the past 20 years, more particularly since it had the express approval of the House more than 12 years ago. Further, by section 299 and schedule 11 of the 2008 Act, Parliament has amended and clarified the law so that secure and assured tenancies will only end when the order is executed. Although those provisions are not yet in force, when they come into force they will largely only be prospective in their effect. In my view, we should not reconsider the view expressed by this House in Burroughs that Thompson was rightly decided so far as secure tenancy is concerned. In the absence of any submission of that effect from the bar, in the face of discouragement from counsel who are highly experienced in the field, wrong for this House effectively to go back on the previous approval of a long-standing decision which had been acted on in a plethora of cases, when there is in place amending legislation having the same effect as such a reversal, in which Parliament has decided to amend the law only prospectively. Further, in Hassan, the Court of Appeal has approved a form of suspended order for possession, which would normally avoid the secure tenancy determining unless and until the court makes a further order. And here I am, back like the bad penny, to invite this court now to do the task that I invited the House not to take in Mosley and White and that is to apply the logic that Lord Newburger applied to Section 9 to the Housing Act of 1985 and to adopt the powerful argument, as he described it, as to why Section 82.2 should be read in the way that we have described.
Well, assuming that we don't hold it against you that you didn't take the point before, let's treat that as water under the bridge. There are still 2 points that come from paragraph 92
Yes, and I
on
must
which we
deal
need
with
help.
those.
I mean, this point that it's been acted on, and I think Mr. Drabble picks that up as a point of real importance. And then there's the 2008 statute, and
Yes.
the fact that Parliament appears to have assumed the law has stated needed correction, and as it were, sort of underscored the state of the law as it was prior to that amendment.
And those are the 2 points which I now wish to address, if I may. The reason I'm back, my lords, as my lords and my lady will appreciate, is that we've identified what we say is a very limited class of persons who've suffered grave injustice as a result of the old regime applying. And those are the failed successors. The people who have found that they cannot succeed to what were thought to be secure tenancies, because in fact, if one traces back through the housing management history, one can find an old suspended possession order which has been breached. And of course, Mr. Alan Austin's case is the paradigm. He lives there for 18 years, he dies, his brother comes forward to take over, and then we find, going back through the file, 18 years earlier, a suspended possession order with a breach. That class of individuals was not mentioned to their lordship's house in Knowsley and White, and is described in our present printed case at paragraphs 25 to 28. We know how they are, how they arose, and I have to accept that I professionally did not draw the attention of the House of Lords to the existence of that class of persons when I was submitting
But,
that it was all
Mr.
too
I'm sorry, am I being very obtuse? I mean, there must be other classes who are also disadvantaged by the approach in Thomson Elbridge. Are there not? I mean, if you're right in what you're saying now, there are other disadvantaged classes who also have the benefit, who don't have the benefit of the new legislation because it only operated prospectively.
Yes, my lord. Save this. The new legislation works prospectively to help those who are still alive as tolerated trespassers. So that the people who are, as a result of Burroughs and Brent, and have been tolerated trespassers, are now restored to a tenancy status by the new legislation. So those who have remained alive are now covered by the new statutory regime. That's why all the other consequences, as it were, that might have arisen are largely addressed by the new legislation. What
Do
is
they
not
have to do anything?
I'm sorry, my lady.
I'm sorry, I'm a bit confused about
Yes,
the
I'm
effect of
sorry.
the new legislation. That's my fault, not yours. Do they have to do anything?
Existing tolerated trespassers.
Yes.
No, my lady. The way it works, in summary terms, is as follows. If on the 20th of May 2009 you were a tolerated trespasser, assuming against myself that such things existed, you become, by operation of the statute, a replacement tenant. That is achieved by Part 2 of Schedule 11 of the 2008 Act, to which we shall have to come shortly. The replacement tenancy starts on the 20th of May, so that there is, for all tolerated trespassers, a potential gap. That is to say, the gap between the time they were last a tenant and the start of the replacement tenancy. That gap is described in Schedule 11 as the termination period.
So described as
The termination period.
yeah. Yes.
Section 11 then makes rather complex provisions as to circumstances in which the termination period is treated as a period during which you were a tenant.
So for some purposes it is and some it isn't.
It's exactly so, my lady.
Yeah.
And those purposes are either those prescribed by the statute, and there are 4, I believe, of those, or those which a court may direct if you ask a court to adjudicate on your rights during the termination period. To give my lady perhaps the most obvious example, the statute provides that during the termination period you will be treated as a tenant for the purposes of accruing the right to buy.
Well, that was exactly what
Yes.
I feel sure my lord was thinking about, and
Yes.
I was too.
Well, my lady, that's the answer.
So, in effect, it does operate for very important purposes retrospectively.
Yes. Well,
Although it uses a device which isn't retrospective, nevertheless, the effect is.
yes. My lady, we shall have to come and look at those purposes in a little more detail. I'm simply trying to give what I understand to be an overview of Part 2 of Schedule 11. So to
Are
go
you
back
really
to...
saying that except for your class, there's nobody alive today who is disadvantaged by the prospective-only operation?
Oh, no, my lord, I can't go that far.
No, quite. Well, give us a paradigm example of another class who plainly remain disadvantaged by the prospective-only operation of the Act.
Well, that is a little difficult for reasons I shall have to develop in relation to Part 2 of Schedule 11. There may be people for whom it is still advantageous to apply to the court under Section 85 to resurrect their old tenancy, because getting their old tenancy back is better than having the replacement tenancy with the termination period only for some purposes fulfilled. Now, perhaps if I had a little more time to reflect, and I shall take that time, I may be able to give a better answer to my Lord's question. But the existence of the replacement tenancy, which started by statute on the 20th of May, doesn't prevent the tolerated trespasser who gained the benefit of that replacement tenancy from saying, no, I don't want that, thank you very much. I shall apply to the county court under Section 85 of the Act to postpone the date for possession in my original order, so I get back my original tenancy, thank you very much. Those people doing that will be people who've identified a difference between their old secure tenancy and their new replacement tenancy. What that difference might be is a little difficult to identify as a class. There may be some people who it would be a benefit of. But my Lord, I'll think on that if I may.
I mean, you obviously
I don't say there cannot be such persons.
No, quite. I mean,
can
you
see
see
there can
the point I'm making. I mean, you know, one mustn't have the impression that actually this is an overlooked class who weren't referred to for all the world, as if otherwise there aren't people who, you know, it was recognised would still lose out because of the approach taken in Knowsley.
Yes, my Lord. Yes, it's identifying who they are, given that had Mr. Alan Austin survived, he might have either got a replacement tenancy, to which his brother could have then succeeded, or applied retrospectively to resurrect his old tenancy, to which his brother could then have succeeded. There will potentially be others who will want to revive their old tenancy, who are alive. That's the advantage they have, and they'll be able to identify what the problem is for them and act on it. This is a class who can't do anything if the interpretation of Section 82.2 is correct, as given in Thompson and Elmbridge, because they're simply not addressed by the new statutory arrangements at all. My Lords, I was suggesting that the first of the reasons why it may be necessary to revisit the approach taken by this House in Knowsley to Section 82.2 and the secure tenancy regime is because there is the significant class of which the present appellant is representative who will have suffered grave injustice as a result of the construction that was adopted in Thompson. The second stage is that there is nothing in the new regime which can assist persons in that class. And furthermore, that the impact of assisting them by a more liberal construction of Section 82.2 will be exceptionally limited. There are likely to be, almost as every day passes, a diminishing number of failed successors who are still in possession We've had failed successors since 1986. Most of them will have left. Thirdly, there's never been the possibility contemplated of retrospective legislation for these people. The Parliament certainly knew that there were these people, but there's never been a proposal to address their situation. Only the proper construction of the old Section 82.2 can assist them.
That could be said to be a point against you.
Could be said to be a point against me, my lady. Yes, it could be said to be a point against me.
Sorry, it
That-
is said to be a point
It is said to
against
be a
you.
point. It is said to be a point against me. But we can see that the statutory regime addresses tolerated trespassers who are still alive. It doesn't. It's difficult to see how they could have been addressed without out-and-out retrospective legislation. Such retrospective legislation is not needed if our construction of Section 82.2 is correct. The fifth point is that there's no justification for inconsistent treatment. We now have a situation as a result of Knowsley and White, where in the social housing tenancy sector, we have persons who were able to succeed after their deceased tenant broke the terms of a possession order, and those who cannot. So the spouse of a assured tenant who failed to comply with the terms of a suspended possession order does succeed, but their neighbour who is the spouse of a secure tenant cannot. Let me then come to Mr. Drabble's case, that the situation has moved on, that this court should not now revisit the question because primarily Parliament has revisited it and, if I may, in doing so, adopt also the alternative that a number of people have in the past acted pursuant to it.
I'm sorry, you dropped your voice. I didn't hear that.
I'm sorry, my Lord. There are two aspects. Firstly, Parliament has now addressed the broad landscape, and secondly, there will have been people over the past 20 years who have organised their dealings on the basis of Thompson and Elmbridge and latterly boroughs. My learned friend's printed case first draws the distinction between the separate statutory regimes, the three regimes, and rightly identifies that the Rent Act regime is primarily concerned with the private sector. Inaccurately, however, it is suggested that the assured tenancy regime is also not concerned with the social housing sector. For the reason I've given, the assured tenancy regime is as important, if not more important now, in the social housing sector than the secure tenancy regime itself. So it is wrong to say, as my learned friends do, that the distinction is between, on the one hand, the regime is applicable to social housing and the regime is applicable to the private sector. Secure and assured are applicable to the social landlord sector, in particular the housing associations. Much reliance is placed by my learned friends on the fact that the statutory position has moved on, and it may assist the court if I offer a very brief chronology. February 2006, Harlow and Hall.
Sorry, February 2006?
February 2006, Harlow and Hall was decided by the Court of Appeal.
Yeah.
That really, to use a colloquialism, sets the cat amongst the pigeons. In May 2007, the Court of Appeal in Knowsley and White decides that we have tolerated trespassers in the assured sector too. The combination of those two decisions produces, at last, a consultation exercise by the government, which is launched in August 2007, and which concludes in November of 2007. My lords and my lady have the consultation document at volume 4, tab 52. And I've just mentioned that the paragraph, from the paragraph numbers of that the primary stimulus for the need to act is the situation of blameless tolerated trespassers. And I've described them earlier in paragraph 7 of the consultation.
And it's arising both from assured and controlled and secured, both types of tenants.
Both types of tenants, if the Court of Appeal's decision in Knowsley and White was correct, which, as we saw subsequently, it was not. And it floated the possibility of proceeding with the Law Commission's proposal in relation to the way of dealing with the future. it is right to say that the consultation paper recognised what was already well known, namely that the situation of many landlords and tenants was not well appreciated. Although it had been 20 years that the Court of Appeal had said that the tenancy ends on breach, many landlords and tenants had not appreciated that, and the situation was one of real difficulty in the sector. The consultation closed in November 2007. A summary of responses was published in April of 2008, and my lords and my lady have that at tab 53. In short, the great majority of respondents, including landlords, wanted an end to the tolerated trespasser scenario. There was strong support for the proposition that tolerated trespassers should become tenants again. And the government decided to legislate in response to that, as we see from paragraph 12 of its consultation document. It is striking that the respondents wanted the position changed, even in respect of landlord respondents. The tolerated trespasser is described in the summary of responses by the relevant government department as being an unintended consequence of the legislation. Page 17. As the Court will appreciate, we respectfully adopt that proposition that no one intended that the Housing Act 1985 or its predecessor 1980 Act would produce limbo occupiers of council housing. The summary of consultation, like all the other papers produced by the government, singularly identifies the tolerated trespasser as being the creation of the courts rather than the creation of Parliament. Indeed, my Lord Hope kindly drew my attention to the way in which that was put in the first of the consultation documents in another case, but it certainly appears in the summary of responses and elsewhere. In 2008, the Housing and Regeneration Act was passed by Parliament, and as is the modern way, the relevant government department was required to produce an impact assessment setting out how it would impact on the sector. The impact assessment is again contained in the papers which are before the House, before the Court, and the relevant section of the impact assessment on the Act, as opposed to the consultation proposals, starts at page 281 of that document, and the document is itself at tab 55 in volume 5.
So it's 455, paragraph 2.81.
Sorry, page 281. It's a frighteningly long document, yes. I'm afraid, and it's at tab 55
yes.
behind in volume 5.
Volume 5?
Volume 5, my lord, yes.
Okay.
You gave us the date when the 2008 Act was passed, I think.
It was 2008, my lady. I believe it was July. Unfortunately, you have the long title without the date in it, and I'll check that over lunch. Sorry about that. The Act was therefore in place, and the impact assessment had been produced before Knowsley and White was decided in this court, in the House of Lords, on the 10th of December 2008.
Could I, sorry to trap you and hold you back, I'm just trying to find the page number. Page 281, you said in volume 5, tab 55.
Tab 55, right?
Is it 54?
It is 54, my lord. I do apologise, yes. I should have gone to it rather than...
So it's page 54, page 281, and we have the...
It's the way in which this works, my lord, if we're there together. Tab 54 in volume 5
yes.
is that the relevant government department has to provide an impact assessment of each of the provisions of the Act, and at page 281 it gives the impact assessment of the tolerated trespasser provisions, and that is the document that starts on page 281.
Yes.
And my lord, see, for example, the summary on page 283, the non-monetised benefits are described at the bottom as restoration of tenancy status and rights to existing and future tolerated trespassers, simplified management systems for landlords, removal of challenge relating to voting rights in tenants' ballots. Just explain that last. It had been found that a number of limbo occupiers had been voting in relation to the future disposal of estates of council housing, and had to regularise the position in relation to that. And then the evidence base is set out, costs and benefits and so on and so forth. And at page 289, one finds the figures and the assumptions in relation to the number of people. The number of deaths is dealt with at page 289, paragraph 22, where it is projected how many people have died each year and lost the right to succession. 150 people a year is the estimate in England alone, page 290, paragraph 22. Indeed, perhaps going back to my Lord Brown's question to me, paragraph 48 on page 294, the sentence, probably the most significant aspect of property rights is that at present, where a tolerated trespasser dies, there are no succession rights, whereas if an occupant were to remain a tenant until death, the succession rules would apply. And it might be said that the draftsman is there identifying the most important of the changes or issues arising in relation to tolerated trespassers. The printed case of Malone and Friends suggests that, notwithstanding the statement in the summary of responses, there was a shift from a decision to offer to replace the tenancies of tolerated trespassers by the time the statute was enacted. My respectful submission, that's wrong. Parliament had always been invited to give these tolerated trespassers replacement tenancies rather than their original tenancies back. And that's why we see the provisions in the form that we do. In my chronology, I had reached December 2008 when Knowsley and White was decided in this court. By that date, Schedule 11 had been enacted but not commenced. Commencement of Schedule 11 was deferred in order to have a further consultation about a subclass. That subclass was situations in which the landlord had transferred its stock. So what do you do about a situation where a landlord has limbo occupiers, but before the replacement tenancy regime came along, transferred its stock to a housing association, something of that nature? So there was a consultation exercise about that, which delayed the implementation of the new regime. The commencement took place on the 20th of May 2010, pursuant to a commencement order, and most of the provisions of Schedule 11 were brought into force on that date.
29, surely, not 2010.
Sorry, my lord, 29, yes.
It must be, yes.
In those circumstances, my lord and my lady, may we go to Schedule 11 itself? It's in volume 4 at tab 48.
We're really now looking at what appears in the amended form in the appendix,
Yes.
is that right?
So these are, as it were, the amending provisions,
Yes.
and the recipe you get is what
Yes.
is now the filleted version of the 1985 Act in the appendix. But may I stay with the tab 48 provisions for present purposes, my lord, because I think it's the easiest way to deal with them. In Schedule 11, Parliament decided to do two things. Firstly, to prevent the possibility of future creation of tolerated trespassers. And it dealt with that in relation to the statutory regimes as follows. First, it deals with this in Part 1, with reference to the Housing Act of 1985. The changes there are swept up in paragraphs 1 to 4. And the most important of them are the changes in paragraph 2 of Schedule 11, which restructure section 82 and eliminate the wording of the old section 82.2 and replace it with what are thought to be these clear words: the tenancy may be brought to an end by the landlord obtaining an order of the court for the possession of the dwelling house and the execution of the order. And for good measure, subsection 2 now provides, in the case mentioned in subsection 1a, the tenancy ends when the order is executed. That wording may occasion the need to revisit my Lady Hale's judgment in a case called Dunn about the meaning of the words executed, but it's early days and we're not there yet.
We shall await with anxious enjoyment.
Well, yes, my lady. So that's the Housing Act 1985. Over the page, notwithstanding that Knowsley and White had been decided, it was nevertheless decided to implement the amendments to the Housing Act of 1988, even though they were all now redundant as a result of the decision in Knowsley and White. So paragraphs 5 through to 9 make the necessary changes to the Housing Act 1988 for assured tenants, which were once necessary, perhaps, but are certainly not necessary after Knowsley and White. And my lords will see, looking at paragraphs 1 through 4 of the first part of the schedule and then comparing them with 5 through 9, that what is happening is that in each case the same changes are being made. We get rid of mean profits, we get rid of payments after termination, we get rid of the spouse provisions, all that goes because the tenancy does not determine until execution. Paragraphs 10 through to 13 deal with the amendments to the Housing Act 1996, which address the position of introductory tenants, and for whom we need make no further mention. It was obviously not necessary to amend the Rent Act, because under the Rent Act the tenancy does not end until the person is put out. Transitional provisions in paragraph 14 are important. They provide that, subject as follows, this part of this schedule does not apply to any possession order made before the commencement date. So there is no retrospectivity of section 82, the amendments thereof. However, 14.2 provides this part of this schedule does apply to possession order made before the commencement date if the order applies to a new tenancy by virtue of paragraph 20, we'll come to that in a moment, or a tenancy which has not ended pursuant to the order before that date. So if, for example, you were in the lucky position of being subject to a 28-day possession order and before the 28th day, the 20th of May, fell, then the amendments apply to your order.
Or if there hadn't been a date in...
Or if there hadn't been a date in the order, or there hasn't yet been a breach. Yes. Paragraph 14.3 can be ignored because paragraphs 3.3 and 8.3 were not commenced. And I don't think we need anything further from paragraph 14. So, my lords and my lady, the function of Schedule 11 Part 1 is to prevent there becoming any more tolerated trespassers, to the extent that that was necessary. As I've indicated, Knowsley and White had decided you couldn't have them for assureds anyway, and as we respectfully suggest, boroughs had wrongly decided you do for Housing Act 1985. The function of Schedule 11 Part 2, which is over the page, it is to deal with those who were already tolerated trespassers. And Part 2 makes provision for replacement of certain terminated tenancies. 15. In this part of this schedule, an original tenancy means any secure tenancy, assured tenancy, introductory tenancy or demoted tenancy, in respect of which a possession order was made before the commencement date and which ended before that date pursuant to the order but not on the execution of the order. So it's right to say, as my learned friends are entitled to do, that paragraph 15b accepts the premise that there can be possession orders which have determined tenancies before the date of their execution. And indeed, may be said that this is entirely intended to reverse what had been understood to be the law as decided in Thompson and Elbridge and Burroughs and Brent.
But you can say, I suppose, that because it applies to assured tenancies, also it suggests that the House of Lords got it wrong in Knowsley.
That could be suggested, my lord. The point I take, that is a nice point, I'd take that one.
Yeah, I mean, it's probably a rather unrealistic point, but so far as it is a point, it's in your favour, I think. It shows that you can't really treat the 2008 Act as a guide to what the law was before then.
Exactly so, my lord, and I'm afraid that is a point I wish to develop. That point is right. The other feature of it is that the retention of the assured tenancy regime demonstrates the symmetry between the Housing Act 1985 and the Housing Act 1988 was intended to be retained. It would appear that Parliament decided it was worth changing the wording of the 1988 Act in the same form as the wording of the 1985 Act was being changed, no doubt because the same housing officers in housing associations were having to operate both regimes, thus demonstrating that it's important to treat two schemes as working in the same way. In our respectful submission, that was the position before these amendments, but here we are, Parliament doing a belt and braces. It's paragraph 16 that creates the new tenancy, and it provides that a new tenancy of the dwelling house which was let under the original tenancy is treated as arising on the commencement date between the ex-landlord and the ex-tenant if, and then it's a requirement that the home condition is met, i.e. the tolerated trespasser has been in occupation, and the ex-landlord is entitled to let the dwelling house. And the further requirement is that the two parties have not entered into another tenancy after the date on which the original tenancy ended. Subparagraph 3 makes provision for the termination period, to which I referred in my earlier description. In this part of this schedule, the termination period means the period beginning with the end of the original tenancy and ending with the commencement date.
I.e. while he was a tolerated trespasser.
Yes, my lord, that's right. If you ever were a tolerated trespasser, then the termination period is that period, the period for which you were in limbo. So, paragraphs 15 and 16 telling us about the application and the operation of the new tenancy regime. The heading above paragraph 17 is nature of replacement tenancies, and it tells us in short order that if you were secure, you become a secure tenant. If you were assured, you become assured, etc., etc. Again, the reference is to assured all unnecessary, unless Parliament to be treated as having thought that Knowsley and White was wrongly decided. 18, the new tenancy is subject as follows, to have effect on the same terms and conditions as those applicable to the original tenancy immediately before it ended. So you try and find out, in a case like Mr. Alan Austin's case, what his tenancy terms were in 1987. And those are now his terms. And then at subsection 2, the terms and conditions of the new tenancy are to be treated as modified so as to reflect, so far as applicable, any changes made during the termination period to the level of payments for the ex-tenant's occupation of the dwelling house. It's not quite clear how this works, but the intention seems to be that if the rent went up while you were a tolerated trespasser, then your rent from the commencement date will be the rent that a tolerated trespasser would have paid had they been a tenant. That's causing particular anxiety for those landlords who charged a different rent to tolerated trespassers and others, but we'll come to that. Subsection 3, the terms and conditions of the new tenancy are to be treated as modified so that any outstanding liabilities owed by the ex-tenant to the ex-landlord in respect of payments for the ex-tenant's occupation during the termination period are liabilities in respect of rent under the new tenancy. And so, with great respect to the draftsman, it goes on. Because it's been decided that the way to deal with this is to create new tenancies and have a back period or a gap, you then have to make provisions like this as to what the nature of the new tenancy is and so forth, and what happens about the rent and arrears, and that Parliament has sought, insofar as it can, to do.
When you're using rent to include mean profits.
Sorry, my lord?
You're using the word rent to include mean profits.
Yes, I am there, my lord, yes.
Well, paragraph 3 is turning what, if you're wrong, will mean profits into rent.
Yeah.
Yes, my lady,
Yes,
that's
our
right.
liabilities for rent. Yeah.
Well, yes, but one of the great advantages, if I'm right, is that we don't need this schedule at all. That's not to say that this... and that's not just, if I may say so, a cheap or jury point. It really demonstrates what Lord Neuberger was saying. This is a fantastic piece of drafting in Schedule 11, and if you have a wet towel and 6 hours to spend, you can in fact work out what a replacement tenant is and what rights they have and so on and so forth. And this has all become necessary because it was decided that the policy of the 1985 Act was that we would have things called tolerated trespassers in limbo and so on and so forth. Nothing better than Schedule 11 could demonstrate why that shouldn't be held to have been the law. Paragraph 20 deals with the possession order, because nothing in the new arrangements expunges the old possession order. So paragraph 20 creates an unusual situation in which, despite the fact you have a new tenancy, you are subject to the old order. So paragraph 20 provides the possession order in pursuance of which the original tenancy ended is to be treated so far as practicable as if it applies to the new tenancy. Any court orders made before the commencement date which are in force relate to occupation of the dwelling, made in contemplation or in contemplation of consequence with the possession order, are to be treated so far as practicable as if they apply to the new tenancy. So it appears that the old possession order, if you take a case like Mr. Alan Austin's case, had he remained alive to the 20th of May 2009, that possession order would still be in force. Section 21 then deals with continuity of tenancies, and it provides the new tenancy and the original are to be treated for the relevant purposes as the same and as a tenancy which continued uninterrupted throughout the termination period. So it's paragraph 21 that does the job that I was describing in my overview earlier. It provides that for certain purposes you're treated as not having a gap. And the certain purposes are A, determining whether the ex-tenant is a successor in relation to the new tenancy. So you don't get a double bite because you had a succession while you were a tolerated trespasser and then a succession again. You're not treated as having a fresh start if you were a trespasser, if you were a successor before you lost your old tenancy. B, calculating the qualifying period for the right to buy. C, determining the commencement date of the condition set out in a particular ground for possession. That's to do with decanted tenants and nothing turns on it. Or D, any other purposes specified by the appropriate national authority by order. So in other words, you can regulate for situations in which they will have an infill of the termination period. And then finally, in subsection 3 makes provisions for proceedings on a relevant claim where the court may order the new tenancy and the original tenancy to be treated as the same, and that is the discretion of the court to which I referred earlier.
Would that be a convenient point?
Yes, it would, my Lord, because I'm done with Schedule 11 there. Thank you very much.
We look forward to seeing you at 2 o'clock.
Thank you.